God save the state and this honorable court.
Good morning, everyone. Before we begin our first case, I want to recognize Professor John Corzin from Wake Forest Law School and his appellate advocacy students. Wake Forest has produced, their law school has trained so many of the former justices and current justices of our court. You can look up here and see former Chief Justice Billings, who I understand is still a professor emeritus at the law school, and Chief Justice Lake. And then, of course, we have two justices that are currently on the court that were trained at Wake Forest, Justice Berger and Justice Dietz. So we are delighted to have the Wake Forest students with us today. That said, this time I'm going to call our first case this morning. It is State versus Phillips, and we'll hear from the appellant.
Mr. Chief Justice, Associate Justices, and may it please the Court, I'm Hiram Hemingway with the North Carolina Department of Justice on behalf of the state. I'd like to reserve 5 minutes for rebuttal. The common law prohibition on excessive force protects the right to defend the home while simultaneously affording significant protection to human life. Section 1451.2 of the North Carolina General Statutes, construed in light of the common law and this court's precedents, preserves this important rule which limits the use of deadly force to that which is necessary or reasonably necessary under the circumstances. The Court of Appeals' contrary decision should be reversed for 2 reasons. First, it is not supported by the text of Section 1451.2. Second, it creates absurd and deadly results the General Assembly could not have intended. Beginning with the text, I'd like to address 2 primary concerns with the Court of Appeals' statutory analysis. First, it ignored the common law and this court's clear intent requirement. Second, it misunderstood both the purpose and effect of Section 1451.2. Beginning with my first point, more than 100 years ago in Seward, this court warned against lightly presuming legislative intent to make fundamental changes to the common law. And since Blue, this court has consistently interpreted defensive force statutes which hew closely to the common law to preserve common law rules absent a clear contrary intent. Indeed, in McLymore, this court qualified its holding that the common law of perfect self-defense was supplanted by sections 1451.3 and 4.
This doctrine doesn't really adhere very closely to the common law of self-defense, right? Because imagine a scenario where you live alone in your home, you wake up in the middle of the night, you hear a noise downstairs in your living room. So you take a gun out of your dresser drawer and you walk downstairs and you see a person standing in your living room. You can just walk up and shoot them in the back of the head, kill them. And that would, under the Castle Doctrine, on that evidence, the state could never rebut the presumption, so you would be entitled to the defense. Do you disagree with that?
So, Your Honor, I have a couple of responses to that. One, I think, assuming those are the only facts that exist, I think a prosecutor would be wary of even bringing a case because I think the facts would be so strong that the reasonable likelihood of success would be very low. Obviously, in Castle Doctrine cases, there's generally much more evidence. There's evidence to draw inferences to potentially rebut the presumption and other issues of fact. But based on those facts alone, I agree it would be difficult under the common law, under the Castle Doctrine to proceed.
But there would be questions under the common law that you, in the Castle Doctrine, you wouldn't get to. So, for example, that, if you just walk up and put the gun into the back of someone's head and execute them, knowing no other facts, a reasonable jury may conclude that force was excessive, because you didn't have enough to form that reasonable belief, given what you knew at the time. And it seems to me that part of the legislative policy decision here was to remove those kinds of questions from someone when you're inside your own home, that instead of having to process what you would normally have to do in the common law, all of those questions about comparing the force you're about to use with the threat that you face, that they're creating a presumption that you don't have to do any of those calculations in your mind if you're in your own home and you know that the person that's there doesn't have a lawful right to be there.
So just to be clear, under the common law defense of habitation, that wouldn't be justified under these circumstances because the common law defense of habitation ceased to apply once the intruder gained entry to the home. So I just want to be clear on that. The Castle Doctrine obviously preserves the expansion of that common law rule that first occurred in section 1451.1, which was abrogated or repealed when these statutes came into effect, that expanded not only to prevent unlawful entry, but to terminate the unlawful entry. And so it does become more expansive in that regard. However, going back to the text of the statute, beginning in 1451.3, it states that a person is justified, in relevant part, a person is justified in the use of deadly force under the circumstances permitted pursuant to section 1451.2. It directs us to 1451.2.
And what's interesting about that is the previous parts of paragraph A seem to be getting at something that would be a common law self-defense or excessive force theory, right? Because when you're talking about things like do you reasonably believe conduct is necessary to defend yourself, that sort of thing, that's incorporating some of what is in for example, the pattern jury instruction on excessive force. But that last section is essentially saying forget everything we just said. However, a person is justified in the use of deadly force under the circumstances of point 2, which is the Castle Doctrine, right? So what does that do to the beginning of point 3A?
So, Your Honor, I disagree that paragraph A1 is incorporating an excessive force principle. And the reason for that is that common law, the elements of perfect self-defense are one, you believe it is necessary to kill based on the circumstances. 2, that belief is reasonable under the circumstances. And so here, rather than use the language necessary to kill, it replaces that with using deadly force. And so under paragraph A1, reasonably believing that deadly force is necessary to prevent imminent death or great bodily harm more or less condenses the first 2 elements of common law perfect self-defense while replacing the necessary to kill language with necessary to use deadly force. And in this court's decision in Richardson made clear that there's a distinction between reasonable fear and whether the force ultimately used is greater than necessary or reasonably appears necessary under the circumstances. There's certainly overlap in the concepts, but they are distinct.
Yeah, I mean, I agree with everything you're saying. I want to make sure you understand my point, though. Could you not read the statute to say, however, a person is justified in the use of deadly force? So that would mean the absolute defense. Under the circumstances in 1451.2, and then you flip back, and there's no excessive force, there's no aggressor doctrine. The only standard there is a rebuttable presumption if the person's unlawfully in your home that you presume they're there to inflict death or serious bodily harm, and the state has the burden to rebut the presumption.
So, Your Honor, I think it's important to note that paragraph A2 tells us that deadly force is justified under the circumstances permitted pursuant to 1451.2. But when we turn to 1451.2, it's noticeably absent is a statement saying these are the circumstances. Deadly force is justified when. And so it requires construction. It requires this court to construe that provision. And when we look at the various paragraphs in section 1451.2, paragraph B stands out for many reasons. One significant reason is it tracks closely with the common law defense of habitation. The triggering conditions that are the 2 triggering conditions and the presumption itself closely mirror the common law's requirement that you be acting to prevent an unlawful forcible entry. That's the triggering conditions essentially. And then the circumstances of that unlawful entry invasion give rise to a reasonable fear of death or great bodily harm. That's what this presumption does. And so we have when we compare the common law with the presumption, it appears that to the state, the presumption, once it arises, essentially satisfies the first 2 requirements that would have been required at common law for defensive habitation, that you be acting to prevent an unlawful entry and that you have a reasonable fear of death or great bodily harm. And pursuant to this court's precedents and for example, in the decision just 3 weeks ago, the Terry decision, talked about taking the statutory lattice and laying it over the common law. When we do that with paragraph B, once the presumption arises, those first two requirements of the common law are satisfied, leaving behind the requirement that the force used be no more than necessary or reasonably appears necessary under the circumstances.
Well, doesn't your interpretation negate the statutory protections available to homeowners, business owners, people in their car? I mean, it would seem like if we're going down the common law route anyway, the statute becomes unnecessary.
So I disagree that the statute becomes unnecessary for the following reason. The purpose of the text, of the purpose and effect, I want to talk about both of those. The purpose of paragraph B is clear from the text. It creates a rebuttable presumption of reasonable fear of death or great bodily harm when the two triggering conditions are satisfied. And that's not unlike the common law, where if the circumstances of the invasion create a reasonable fear of death or great bodily harm. Those are very similar. The difference here is that under the common law, you would have to present evidence, argument, you would have to have inferences, something that from which you could argue there was a reasonable fear of death or great bodily harm. Under the statutory requirements, once those triggering conditions are met, there's no further obligation to present any evidence whatsoever. There is a presumption, a rebuttable presumption of death or great bodily harm, and so that does another thing. Generally, and in the common law case, the defendant would make a prima facie case justifying the instruction, and then the jury would be faced with a question of fact whether the state proves beyond a reasonable doubt that there was no reasonable fear or one of the other elements. Here, under the statute, it's similar, except when the state comes up to argue, the starting line has changed. It's no longer just a factual dispute, but it is presumed proven in the defendant's favor that they had a reasonable fear of death and great bodily harm, and the state has the obligation of disproving that all the way back to beyond a reasonable doubt.
So, but in section G in the Castle Doctrine, where it says then, this section is not intended to repeal or limit any other defense that may exist under the common law. Things like the excessive force theory, the aggressor doctrine, duty to retreat, all those things, those are not defenses. Those are, I mean, you really think of them sort of as exceptions to the defense. They're reasons that the defense wouldn't apply. And the legislature didn't say those principles from the common law survive. So what I'm struggling with is if the legislature said, however, a person is justified in the use of deadly force if the circumstances in the Castle Doctrine are satisfied. And as you said, what it's doing is just creating this rebuttable presumption that until the state has rebutted that presumption, if the state can't do it, then that seems like the legislature is saying that's the end of the analysis. No questions about who was the aggressor, excessive force, any of those issues. Why is that wrong?
Several reasons. First, the state reads paragraph G to demonstrate an intent to not supplant the common law defense of habitation. For example, because of section 1451.4, there are circumstances, and I think it's new, I'm not familiar with a case where the aggressor doctrine plays into defense of habitation under a common law, but the statutory Castle Doctrine, if there's evidence that shows you were the aggressor as defined in 1451.4, the Castle Doctrine is unavailable to you. Therefore, a person in that circumstance would not be able to avail themselves of the statutory Castle Doctrine, but could still avail themselves of the common law, which would be more limited to preventing the entry rather than terminating it.
But are you familiar with Justice Berger's concurrence in the Hicks case?
Yes, Your Honor.
Seen that one? I mean, I joined it, so of course I found it persuasive, but the problem with that is that the provocation, you seem to be getting at something different when the legislature is saying apply the initial provocation standard in the standard ground. The idea there would be you provoked the person to unlawfully enter your home, not that if they're in there, you're the one that sort of resorted to force first. Because again, you can walk down the stairs in the middle of the night, and if that person's not supposed to be in your house, you live alone, you can just execute them. And the legislature said that's justified. So it's hard to see how you could use an aggressor instruction in the Castle Doctrine unless it was you provoked them into unlawfully coming into your home.
And I agree, Justice Dietz, conceptually it is difficult to imagine how the aggressor doctrine would apply in the scenario where you wake up and there's an intruder already in your home. I think it makes more sense if there's something happening off of your your property, you provoke something, and then you retreat to your home, that might be a situation where the aggressor doctrine then would apply and would disqualify somebody from the statutory defense. But I want to, sorry, Your Honor, it's a long question. I think I forgot part of.
I think you've answered my question. Thank you.
Okay, I appreciate that. So returning back to the text, I want to make clear that this court has made clear repeatedly that statute should be construed to abrogate, to alter the common law only when that disposition is clear. That's what this court said just 3 weeks ago in Terry. And the Court of Appeals decision does not rest on any such clear intent. The Court of Appeals decision rather rests on a sort of syllogism that since no force can exceed deadly force, excessive force is impossible if the presumption is not rebutted. And this court has long limited the use of deadly force, even when it might otherwise be justified, to that which is necessary or reasonably necessary. And this gets back to my initial point that taking another person's life, using deadly force against someone, is justified only in the most limited circumstances. There's a great...
Right, but counsel, that gets back to my prior question. Doesn't that require us to read something into the statute that's not there, or to basically rewrite the statute when it appears clear and unambiguous on its face?
So, Your Honor, I don't believe it requires the court to rewrite the statute. Again, going back to the text of 51.3 and how it directs us to the circumstances permitted under 51.2, there are no circumstances permitted discussed. All that is discussed in 51.2 is there's a presumption of reasonable fear that arises under these circumstances. And I believe it stretches the text beyond its meaning and intent to take that and turn that into the circumstances itself. And this court's precedence begins with the common law. And the common law remains in effect until abrogated, until a clear legislative intent is demonstrated to alter.
I hate to interrupt you, but I guess, so you think it's unreasonable to read the circumstances permitted under the Castle Doctrine to just mean circumstances where the state is unable to rebut the presumption? So, in other words, circumstances in which the Castle Doctrine protection applies. You think that's an unreasonable interpretation? I
do, because the text of 51.3 says a person is justified in the use of deadly force under the circumstances permitted. There isn't a provision of 51.2 that tells you when deadly force is permitted. What it does is it describes a person using deadly force under certain circumstances is entitled to a presumption of reasonable fear. And those are two very different points. They're closely related, but they're distinct.
If you say that, though, aren't you rendering A2 in 14-51.3 surplusage?
I don't believe so, Your Honor. The legislature is presumed to understand this court's holdings that the common law remains in effect until abrogated. That's their own statute, Section 4.1. They're aware of their statutes. They know how this court construes things. It has been consistent throughout the years that the legislature, if they want to alter the common law, they can and they have.
But the provision says under the circumstances permitted in 14-51.2. If you're saying 14-51.2 doesn't describe any circumstances, then how is this a meaningful provision?
Well, Your Honor, it's somewhat difficult to square that language with the statute. And when I looked up the history of these sorts of laws, this is in the brief, so please cut me off if you feel this is inappropriate. But the Florida statute, for instance, that I believe this was modeled after, has a provision in the Castle Doctrine that says deadly force is justified when, and then articulates it. And so it has this language, and then in the next one, it tells you when it's there. And for whatever reason...
So it's just sloppy borrowing is what...
I don't know that it's sloppy borrowing, Your Honor. I think, again, the legislature made conscious decisions about what provisions they would borrow, and I think the fact that they didn't include that language is one indicia that they intended to preserve a common law rule that was not clearly addressed by this provision. And that is consistent with this court's precedence that when a statute addresses, for instance, 2 of the 3 common law elements of the Castle Doctrine, that the common law gives the last meaning and effect to that statutory provision. They are read in harmony, as this court has done repeatedly over the years.
Couldn't your, I'm sorry, Counsel.
No.
Couldn't your friend on the other side argue with regard to the Florida statute that the North Carolina legislature intended the protections to be broader than those merely delineated in Florida.
So I don't have the text of the Florida statute in front of me to go over point by point, but what I can say is I don't believe so, Your Honor, and the reason for that is because, again, the background from which statutes, the fundamental principle that this court has established is that when you construe a statute that is operating in territory previously, occupied by the common law, you start with the common law and you look at what the common law did. And to the extent that the statute does not address an aspect of the common law remains in effect. That was part of this court's decision in McLymore, that to the extent the statute does not address an aspect of the common law remains. And that fits perfectly with here. It makes perfect sense to use the common law together with the statute to provide the circumstances permitted, especially when the statute hews so closely to the common law itself.
So we've used up a lot of your time, and I want to make sure you have some rebuttal. So I want to ask you a question about prejudice. Suppose we reject your argument, we think there was an error. Do you think the Court of Appeals decision in this case engaged in the correct analysis of whether that was a prejudicial error?
So I have some concerns with the Court of Appeals. It picked up on a juror making a statement that, could you repeat the last? And this wasn't really something that either myself or my friend on the other side argued or discussed in our briefs to the Court of Appeals. This was kind of the Court of Appeals discovered this point on their own, but it used that to say, obviously, look at this, they were clearly confused by these instructions. When you look at what the trial court understood that to be, and you compare the first iteration of the instruction with the second, the trial judge omitted certain numerical signposts. And granted, these instructions are lengthy, even without the added language. These are lengthy, complicated instructions. So those signposts, the state believes, are important and help guide the jury, especially I don't recall it in this circumstance if the jury was given a copy of the instructions or not, but that doesn't always happen. And so those numerical signposts are very important. And when the judge went back and did that, the record does not reflect any further confusion on the part of the jury. And so in that regard, I have concerns. But going to if the Court of Appeals is right and the state is wrong, then I do think there is a problem, because admittedly it would have given the jury a means to acquit that if this court holds against the state that is not apparent, that is unlawful, and that's a problem, because at that point we don't know which basis they found the defendant guilty on, and I think that there would be prejudice. So I do agree with that. And I just quickly, I want to discuss the absurd and deadly results of the Court of Appeals decision and the defendant's arguments in support thereof. First, it endorses the outright execution of an individual by the occupant of a home, workplace, or motor vehicle, even if there are available and sufficient non-lethal options to prevent or terminate the unlawful entry. And granted, that's going to be the rare situation, but those situations do exist. And under the common law, those situations would require no more force than necessary or reasonably appears necessary to the defendant. And second, the Court of Appeals decision insulates defendants against extreme overreactions that cause injury or death to innocent bystanders. This court has various decisions that have found that, the number of shots, discharging 15 times, for example, was evidence of excessive force. And if those shots injured other people, those could be additional charges. But under the Court of Appeals decision, the defendant's arguments, there would be no recourse for someone injured or killed for an obvious, outrageous, excessive force. And the state does not believe there is anything in the text of Section 1451.2 that indicates the General Assembly intended to grant such a license to kill. I'd like to reserve the rest of my time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
Good morning. May it please the court. I'm Mary McCullers-Reese for the appellee, Angela Phillips. This case is about whether North Carolina's legislature intended for the state's Castle Doctrine statute to be limited by the common law concept of proportionality of force. The issue before this court arises because the trial court gave a Castle Doctrine instruction, but added a categorical prohibition on excessive force. because the added instruction contradicted the plain language of the statute, provided an unintended route to conviction, and prejudiced Ms. Phillips, the Court of Appeals granted her a new trial. Ms. Phillips respectfully asks that this court affirm. This case arose because an angry and intoxicated neighbor showed up at Ms. Phillips' front door to confront her. The neighbor was not invited, and despite being told to do so several times, she would not leave. The confrontation ended with Ms. Phillips standing in her own front doorway, shooting and seriously injuring the neighbor, who was on Ms. Phillips' front stoop. At trial, defense counsel asked for the pattern and jury instruction 30880, but objected to the trial court's prohibition of excessive force in the context of the Castle Doctrine. The Castle Doctrine statute, 51.2, derives from the principle that one's home is one's castle, and the rightful occupant of her castle should have an expanded right to self-defense when confronted with an unlawful intrusion into her home. The statute, GS 14-51.2, does not prohibit excessive force. This is so, perhaps, because it applies to a distinct and somewhat dire set of circumstances.
So in my scenario of you're coming down in the middle of the night or someone, even if it's apparent to the homeowner that the person is not armed, you just take out your gun and shoot him in the head. And
If
it's justified, no questions asked, excessive force, anything else.
there is no excessive force in the statute. Once that person has unlawfully and forcibly intruded into the home, then the homeowner does have the right to respond to that intrusion, and there is no limitation on the force. Specifically, the statute's central presumption comes into play where an intruder only where an unlawfully and forcibly has entered or is entering a person's home. So where the moat is being crossed or the castle is being breached, and whether that unlawful entry is occurring is an issue for the fact finder. And where those facts do exist, it's presumed that a lawful occupant may use defensive force that's likely to cause death or serious bodily harm to defend herself. So yes, I agree. Those are the words of the statute.
As the argument would be, but the state could use the fact that it should have been apparent to the homeowner that the person was unarmed as part of an effort to rebut the presumption.
In that I'm sorry.
Go ahead.
And of course, as we don't have without all the facts. In that circumstance, I think the legislature has made a policy decision to side with the lawful occupant of a home or a homeowner instead of the person who has unlawfully and forcibly intruded.
But the point is, it is a rebuttable presumption.
It is a rebuttable presumption.
And in this case, there were two versions of what went on, and you summarized for us the defendant's version, but there were other witnesses who told a different version of what happened on the porch that didn't involve any instruction to leave or any aggression on behalf of the victim here. And so if the jury were to believe that, I mean, both the prosecutor certainly argued that the Castle Doctrine didn't apply here because she was not trying to enter the home. So I guess maybe my question is really going more to prejudice than whether the jury could have found that the presumption was rebutted. But here, there certainly was a version of the evidence from which the jury could conclude that the victim was not trying to enter the home, and that the Castle Doctrine shouldn't have applied here.
Of course, and that would be a factual issue for the jury. The jury got that evidence. I don't think there was a lot of argument against giving the instruction, and that she was not entitled to the instruction based on in the light most favorable to the defendant.
Right, but so I apologize if I'm skipping ahead to the
I'm sorry.
But given, in light of the fact that the court did instruct on the Castle Doctrine, and there was evidence from which the prosecution could argue that the Castle Doctrine didn't apply, how do we ultimately conclude that the error, if we agree that the excessive force instruction shouldn't have been given, if there's evidence from which the jury could have concluded that the Castle Doctrine doesn't apply at all, how do we get to prejudice in this case?
Well, and it's not clear how the jury got where they did, and that's the problem. Even if the jury 100% struggled through this complicated instruction, all the switchbacks, made it all the way through, and followed the instruction exactly as given, we don't know if they convicted based on a finding that the presumption was rebutted or that the force was excessive.
But isn't the question in prejudice not why the jury convicted, but if the correct instructions had been given, is there any reasonable possibility in that hypothetical scenario that the jury would convict again? And I think what Justice Earls is getting at is that the state's evidence, I mean, one way to look at it is the state's evidence was a lot stronger than your client's on whether or not this was a Castle Doctrine case or not.
That the jury should have found that the
Right, and so there, you know, is there a possibility that we conclude there's no reasonable possibility without the erroneous instruction that the jury would have changed the result? What's your view on that?
I don't see how you get there. The instructions, she was entitled to the instruction, she is entitled to the full benefit of it. And the trial court, you know, I think that's one of the things that happened was the trial court came in and said, I don't know about this statute. I have some real doubts about this statute, and that was the reason for the excessive force instruction. He was worried about, well, what if there's a Girl Scout on the porch? What if a Girl Scout's on the stoop? Well, I would contend first that this was not a Girl Scout on the stoop, but first that the instruction would be very unlikely to be given in that circumstances. I think you would be trouble, even the light most favorable to the defense, it would be very hard to receive the instruction. But then that you have a jury, fact finders there to determine whether or not the facts exist giving rise to the presumption. So did I answer your question? I'm not sure if I got off track from what you were asking.
Yes, no, and I think to highlight, I think the reason we're here is the trial court was asking the same questions that I'm asking right now about how the Castle Doctrine, that you can think of some really difficult hypotheticals. I guess your position is, that's right, and those are hypotheticals that the legislature, when making this policy judgment, must have thought about, and they concluded that the text of the Castle Doctrine is what we look at, and don't worry about those scenarios.
Absolutely, Your Honor. It was a policy decision. The legislature had to come down somewhere, and they came down a very defensible policy decision to, I guess if you're tilting the scales, you know, tilt them for the lawful homeowner as opposed to the person coming in unlawfully and forcibly.
Can I ask you about this is going to prejudice still and wanting to make sure that our case law is consistent. Lots of cases instructing that we look at the jury instructions as a whole because it's not uncommon that you have a stray, inaccurate statement. So I understand you to, I think this is page 270 of the transcript. It's the part where the Castle Doctrine presumptions presented, in addition, absent evidence to the contrary. That paragraph, there's no dispute that that's an accurate statement of the law, right? That the court, sorry.
Page 270, this is basically the 30880.
Yeah, it's right before the objectionable part where it says defendant doesn't have the right to use excessive force. The Court of Appeals called it confusing, and I have to agree. I think this court has noted that 30880 dates back a long way before 2011 in bringing on of this statute. You notice, as you read it, that there are three basic prongs. They say, well, if all three of these are true, then, you know, the defendant cannot be convicted. Well, but it doesn't mean the contrary, that if all three of those aren't true, you must defend. And to the extent that it applies that, I think it's a little bit confusing and out of date. Yeah, and I get that. I'm curious that so there's an objection about the wording of this and then the problematic statement, but read as a whole, I want to make sure any rule that comes from this court is consistent with our prior rulings, which I think tends to take a very holistic look and doesn't sort of cherry pick statements because of the discretion that a trial judge has. And so I just wanted your perspective of how we reconcile the parts of the jury instructions that either aren't absolutely wrong or are admittedly right with the piece that you've highlighted as problematic in your view. the problem here, the big problem with this instruction, and the Court of Appeals says, well, if this were just stand your ground, it'd probably suffice, because there is a proportionality put into stand your ground. However, this allowed a detour around the central presumption of the statute is the problem. And so the jury could absolutely have bypassed and convicted based on excessive force. And then, I guess, if you're asking the question, is that possible? Could they have not rebutted? Could they have found that the presumption wasn't rebutted and then convicted because they, well, yes, because they could find that, yes, this person was unlawfully and forcibly entering her home in a very frightening way. She's on her front porch and she's ready for a fight. But I've lost my train of thought.
And so you're probably aware, this is the third time I think this term of court that I've asked these similar questions to someone in your position. The pattern jury instruction also seems to have this defect. So could it be fixed if each time the trial court's instructing on the common law defense, common law self-defense, there's a part in the beginning where the court says something like, and again, you consider this criteria only if you've determined either, the Castle Doctrine doesn't apply or the state has rebutted the presumption. And if so, you must also ask, would that, in your view, correct the problem in this case? So you're emphasizing these are separate. In common law self-defense, we have but if you're in the Castle Doctrine, you're not considering these. What's your view?
Yes, Your Honor, I think that would, I think a flow chart, I think we ought to have a flow chart for these because it's very hard to follow. I mean, we've all thought about this a lot and have law degrees, and I cannot imagine, sending it back with the jury, it is very confusing, and the instruction hasn't been updated in a long time. So if there were a flow chart, or if the verdict sheet were a flow chart, I think it would make it much more confusing. But yes, the Court of Appeals said and I think it's a pretty good solution to say, okay, first has that been rebutted? If it has, then yes, you go on into the excessive force and consider that very clearly. Flow chart, yes, no. If it hasn't been rebutted, then you don't consider excessive force. So I don't know if the visual of a flow chart would help, but it does seem like to make it consistent, that would be a revamp on the 30880 would be helpful. I've lost my thread.
Well, counsel, while you consider perhaps where you are in your argument, let me jump back to something about the Girl Scout example. It seems to me in reading 51.2 that the question of whether someone has unlawfully entered or is unlawfully attempting to enter, that in those scenarios we are focused on the behavior of the victim at that point. Is that an accurate way to look at that?
In terms of deciding what...
Right, so we're not focused in the Castle Doctrine initial question as to whether or not the defendant or the homeowner's conduct was appropriate. We're focusing on the behavior or conduct of the victim.
Absolutely.
So the Girl Scout scenario really doesn't come into play at all if we're properly applying the statute.
Right, a properly instructed jury, properly instructed through the statute. And I feel like I do want to sort of back into, because I feel like I've skipped a little bit into the interrelationship between 51.2 and 51.3, because I do think there is a very sensible way that what the legislature has done here makes sense, plain language of the statute. Those two statutes should be read in unison, in pari materia. They should make sense together. They both apply to self-defense in the home, and they're next door to each other. It's very clear the legislature intended for those two statutes to work together. 51.3 applies to one defending themselves wherever they have the right to be, but also in their home. But it's not tailored like 51.2 as an urgent response to a threat of forcible entry or unlawful entry into the home. So it's not surprising that stand your ground actually does address proportionality specifically. And I know the state disagrees with me on this, but the statute says one standing his or her ground is justified in using non-deadly force to the extent that the person reasonably believes that the conduct is necessary to defend himself or herself. And I'd say that to the extent that language makes clear that the legislature understood how to carve out consideration of proportionality in the self-defense statutes to the extent that, proportionally.
Right, because to follow up on Justice Berger's point, I mean, so for example, if the Girl Scout went crazy and kicked the door in and starts attacking you to force you to buy the cookies, that's what the legislature had in mind. And the reality is, though, the state could try to rebut the presumption and say this is just an elementary school child, and it might be completely different if the Girl Scout's dad is there too, who's this 6'5" biker and is the one that kicked in the door. And that would be the point: is the government left open the door, the legislature, to being able to show that evidence to avoid the really extreme hypotheticals that we can dream up. But in the mine run case, all these questions about what you call proportionality, what, these kind of things like excessive force, they were just never intended to be done in a Castle Doctrine case.
What if the presumption is not rebutted? That is, and again, I think that is the plain language of the statute, and it's a policy choice made by the legislature that we favor homeowners over intruders.
So if we tweak Justice Dietz's original hypothetical, and when the homeowner comes down at night because he heard a noise downstairs, suppose he finds the intruder passed out, intoxicated and passed out, and then shoots the intruder, executes the intruder. How would the Castle Doctrine apply in that situation?
I think at that point, first you have to consider, are they entitled to the instruction? Did they forcibly and unlawfully enter? And I guess if they're unlawfully in the home, they have unlawfully entered. And then the homeowner is, if none of the other, and I'm thinking which of the other exceptions would apply there. I think when they have ceased and desisted, or it's not the exact language, but when they are no longer trying to enter or have stopped trying to enter, I think that might apply in that case. The legislature did list a number of exceptions.
Would that be a scenario in which the state could then seek to rebut the presumption?
Sure, absolutely.
By saying
It's
that
not an
you weren't in reasonable fear of imminent death because the person was passed out?
Yeah, more to the point, yes, Your Honor, thank you. That is more to the point that the presumption might be deemed rebutted at that point.
Right, and we have an actual example of that, right? Because there's a Court of Appeals case, State versus Austin, where the defendant had disarmed the intruder, and a witness saw the victim on his knees on the ground with his hands up, begging, "Please don't kill me, please don't kill me," and then the defendant shot and killed the victim in the head. And the Court of Appeals said, and the defendant got convicted, and the Court of Appeals said the state rebutted the presumption there because, although hadn't actually desisted and left yet, wanted to and was obviously no risk. And so it seems like the door has been left open by the legislature to avoid the really extreme examples that we're sort of dreaming up here about why it might not make sense.
And that, to me, it seems that one response to the state's sort of parade of horribles is this is a rebuttable presumption. And in extreme cases, the state would have the ability to show that the presumption shouldn't apply.
To get the instruction, there are going to have to be facts to get the instruction, and then the jury is going to hear and then the jury is going to be the fact finder as to whether it applies. Are there other questions from the court? I want to answer your questions instead of just talking.
Well, Counsel, I want to, and I apologize for jumping around, but I want to get to the prejudice, or back to the prejudice question just briefly. In the Court of Appeals, the majority focused on whether or not this one juror was confused, and that was prejudicial. Is that an appropriate prejudice analysis, or do we have to look at the factual scenario? I think Justice Dietz touched on this, with the proper standard of review? Do we look at a factual scenario, or do we look at that legal conclusion that the Court of Appeals made? Or I apologize, was the discussion by the Court of Appeals about confusion, was that a factual finding by the court?
I think the court is, essentially, there was factual basis for finding that the jury was confused. I think even if you find that the jury was not confused, the fact that this instruction allowed them to detour around the entire essence of the Castle Doctrine is a prejudicial problem.
But I thought the inquiry was that we have to decide whether, on the facts of this particular case, that there's a reasonable possibility that the jury would have held differently if the instruction had been correctly given.
If the instruction had been incorrectly given, I would contend, yes, that they absolutely could have found differently. I think it is entirely possible and am I not getting to your question? Is that not?
Well, it just seems to me a different question from whether they were confused. The question is, looking at the evidence in this case and the totality of the instructions, the arguments made by counsel to the jury, is it a reasonable possibility that they would have ruled differently?
Absolutely, Your Honor, because I think you could reasonably find that this person was at the door for a fight, so the presumption goes into effect. And from...
Go ahead.
I'm sorry. I know you've got a question. I want to answer it.
Right. Well, I guess what I'm just saying, isn't that the question we have to answer, whether or not they would have decided differently?
And you cannot absolutely determine whether they had the option before them to decide that the Castle Doctrine was not rebutted, but that she shouldn't have used a gun. She should have just shoved her off the porch. So I think, yeah, absolutely, it was prejudicial.
I'm going to jump back and ask it a different way. If we determine that the Court of Appeals analysis on confusion was inappropriate because they should have engaged in a factual inquiry, can we answer that question in the first instance, or do we need to return it to the Court of Appeals?
You can't. I don't think you can decisively determine whether or not they factually convicted on that basis. You can determine they certainly, the route was there for them to do it that way, whether they were confused or not, and that was error. As far as locking down that they went that way, I don't think that might require additional remand. Does that respond?
I mean, I think, well, and correct me if I'm wrong, Justice Berger. I understood Justice Berger. I think what he was saying is, if the Court of Appeals misapprehended the prejudice standard, and the standard is as Justice Earls articulated it, should we be engaging in that prejudice analysis, or should we be returning this question to the Court of Appeals and saying you didn't apply the law correctly? You need to finish the case by examining the prejudice question. Which of those is the appropriate path for this court?
Certainly returning it to the Court of Appeals. I mean, if you straight up, I mean, I think this court has the same analysis before it that the Court of Appeals would have had. If there are no other questions from the court.
Thank you, counsel. Rebuttal.
I'd like to begin by responding to some of the questions that were asked to my friend on the other side. And the first point I want to make is I think that when you compare the common law defense of habitation with 51.2, I think it's rare that there would be a difference in whether a person was entitled to an instruction in instances where the first element was met versus the triggering conditions, because they're almost one-for-one overlap. And anytime you are responding to a forcible entry, even at common law, there's certainly an inference, if nothing else, that would, that generally you can draw enough inference from that the person had a reasonable fear of death or great bodily harm. And so in terms of the work that the presumption is doing, it doesn't seem to be altering that calculus very much. It doesn't, the triggering conditions and the, responding to a forcible entry, those are almost perfectly aligned. And so if you're entitled under one, I think 99.9% of the time you would be entitled to an instruction under the other. There's not much, if any, daylight between them. The work that the presumption is doing is, when it comes to that reasonable fear, where it goes, whether it's simply a factual dispute or whether it's all the way over in the defendant's favor and the state has to push it all the way back. Certainly the state always has to prove beyond a reasonable doubt that it doesn't exist. But in one instance, it's merely a factual dispute, and in the other, it starts all the way with conclusively proven unless rebutted. And that, the state contends, is the purpose, what that presumption is doing. Just briefly on the prejudices, I heard more questions. I think I understand better, Justice Dietz, what your question, and Justice Berger, what your questions were. And under the facts of this case, I do think it's hard to imagine, given the two very distinct stories that were told, imagine a scenario where the jury agreed with or credited the defendant's version of events, but then would have found her guilty for excessive force based on the evidence. I think it's more likely under these facts and the wide difference between them that the jury either would have credited the defendant all the way or credited the other version from the other witnesses. Regarding the Court of Appeals decision, one point I want to make is the Court of Appeals talked about how the trial court could have corrected the situation by stating, if the presumption is rebutted, then you can consider the question of reasonable fear. That makes no sense. If the state rebuts the presumption, it can only do that with evidence of non-existence of reasonable fear. And if the state has proven beyond a reasonable doubt that there is no reasonable fear of death or great bodily harm, the state doesn't need to touch excessive force. There's no need to go there. The state has conclusively disproven the defense being raised in the first instance. And so that solution doesn't make any sense. And it doesn't make sense to try and preserve that question. The Court of Appeals essentially tried to say, well, it's not fully abrogated, it just can't be considered yet. And that doesn't make any sense. The Court of Appeals effectively found that the prohibition on excessive force was completely abrogated by the statute. Picking up on another question regarding reasonable fear, the Richardson decision is a great example of this, where it talks about the reasonable belief that,
I hate to interrupt you, but couldn't there be scenarios where the Castle Doctrine is rejected for a reason other than rebutting the presumption? So what if, for example, the jury determines that it wasn't an unlawful entry? You could still make a self-defense case if you shot someone inside your home, even if they were lawfully there. It might be a hard one, and so then, Bo, wouldn't you have to still, for the jury, break out so they weren't, if we believe that these issues like the aggressor doctrine and excessive force shouldn't be given in context of the Castle Doctrine, you still need to break them out for the jury so they don't conflate them.
I agree that it would be important to do that. In this case, where there's just the Castle Doctrine being presented, that makes no sense. In a different scenario, if the court were to find that excessive force played no role, then it would be important to clarify under each defense what the relevant factors were. I do agree with that. But going back to the question of reasonable fear, that looks at the victim's conduct and the response essentially it evokes in the defendant's mind. Whereas the question of excessive force looks at the defendant's conduct. And there's a correlation between those two because both are looking at the mental state of the defendant. One, the victim's conduct and what it evokes in the defendant's mind. And the other is the defendant's actions. Are they aligned with that reasonable fear that has arisen? And that's where there's a connection between the two principles of reasonable fear and excessive force, but that also demonstrates how and why they are distinct. And again, the common law, both self-defense, perfect self-defense, and defensive habitation have long prohibited excessive force, more force than necessary or reasonably necessary. And the holding or construing the statute to preserve that rule is not, it is consistent with the way excessive or deadly force has been used in this state for a long, long time. And it preserves that important protection so that lives aren't unnecessarily taken. And I'd just like to point out that if the legislature had intended to make such a fundamental change to essentially authorize the execution of an individual in the circumstances we discussed where the presumption remains unrebutted, absolve someone from the legal consequences of a gross overreaction that results in the death or injury of innocent bystanders who just happen to be in the wrong place at the wrong time. Certainly they would have done so with clarity. They would not have asked or made such a significant seismic change to the law in such a subtle, non-direct manner. And finally, I do believe that reasonable fear and excessive force, often the evidence that would rebut one would play together, but not always. There's certainly, one can imagine scenarios where an individual maintained a reasonable fear of death or great bodily harm, but based on the facts, deadly force, taking the life was clearly unnecessary, even clear to that person who took that conduct. And those are the situations where the common law and the statute would operate to preserve life and protect life, while also granting that individual the right to defend their home to the fullest extent necessary. Ask the court to reverse. Thank you.
Thank you, counsel. Mr. Clerk.